Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing, Monday? So, this is a jayz update. So, as you guys know from the last video, that the Judge Torres tore Jay-Z and his attorney a new butthole. I think that's probably the best way I can explain that. And so pretty much what she did was she put them straight and saying, hey, you can't do all of these crazy filings and demand this court to do this, and that, and the third. And, you know, I guess he took heed. I guess he took heed. So we're going to hop right into it. What's up, Thelma? What's up, Buttercup? Yes. What's up, Sophia? What's up, Sophia? Hey. So we're going to hop right into it. So Jay-Z's attorney has filed a new request to the court to try to get this case once again dismissed. But he actually came with a lot of sense, and he I don't want to say strategically, but he followed the court's rules, specifically Judges Torres' rules in regards how to properly request for a dismissal, and we're going to hop right on into it. All righty, so this was actually filed today. There go my dogs. All right, so we write on behalf of defendant Sean Carter, pursuant to Rule 3 of Your Honor's individual practices in civil cases, to inform the court that Mr. Carter seeks to file a motion pursuant to Federal Rules of Civil Procedure 12B6 to dismiss the first amended complaint that was docketed at 29. As y'all can see, this is how you know, because per her rules for that particular court, you have to request a motion to file. File a motion to dismiss. I should have finished that. You have to request a motion to file a motion to dismiss. So now he's following the rules because he don't want to get cussed out again. All right, so in accordance to Rule 3BI of Your Honor's rules, on December 19th, Mr. Carter sent a letter to plaintiff setting forth the basis for this motion and advising that Mr. Carter would file this pre-motion letter if plaintiff choose to stand on her first amended complaint. Plaintiff was required but failed to respond to Mr. Carter's letter within 5 business days by December 27th. Mr. Carter interprets plaintiff's silence as confirmation that she will stand on the first amended complaint as pled. Accordingly, Mr. Carter submits this pre-motion letter concerning his anticipation motion to dismiss, which will raise the following arguments. So these are their arguments as to why they want to file this motion for dismissal. Hey, what's up, Pensy Lola? All right, so here's the first reason. First, plaintiff. Oh, because my Instagram is blowing up. Let me pause this. Okay. First, plaintiff cannot recover for her sole claim under the Victims of Gender Motivated Violence Protection Act as a matter of law because the statute does not have retroactive effect. So, where was this? This is filed in the Southern District of New York. So, remember all of these SA cases that came against Diddy? They did not meet the Adult Survivors Act. That was the same act that Cassie Ventura actually had the opportunity to file under. Since then, I believe it was the 23rd or the 30th of November of last year, the Adult Survivors Act, that was the deadline for anybody who was SA'd during a certain period of time. So they could no longer file under that. So then people started filing under the Gender Motivated Violence Act. And that is what they're saying. So now what they're saying is Jane Doe can't recover under this particular claim because the statute does not have a retroactive effect like the Adult Survivors Act did. So the Adult Survivors Act, I believe that it gave them a window. So if you was violated, X amount of years ago, you have the opportunity to file. I hope that makes sense. So with this one, because it didn't have a retroactive effect under this particular act, they're saying that Jane Doe cannot recover under this particular act. All right. So then says plaintiff asserts a violation of the GMV law for conduct that purportedly occurred in September of 2000, but the GMV law was not enacted until December 19th, 2000, 3 months after the First Amendment complaint claims the conduct occurred, and cannot apply retroactively to create a cause of action unavailable to the plaintiff at the time in question. Who we They actually cited Lois and Niederhofer. And in that particular case, it says that dismissing the GMV law claim related to conduct that occurred before the GMV law was passed, because statute does not provide for a retroactive or immediate effectiveness. So in that particular case, it was dismissed. Ooh, boy, this ain't looking good. A contrary conclusion would violate both state and federal due process protection. This is about to be very, very interesting. Very interesting. Second, even if the GMV law had retroactive effect, it does not to prevail. Plaintiff must show that the violative conduct was committed within New York City. The first admitted complaint alleges that the violative conduct is forced sexual contact, but does not assert that this conduct occurred in New York City, nor could it. According to the first admitted complaint, plaintiff was driven from Radio City Music Hall to a large white residence with a gated U-shaped driveway, a drive that took 20 minutes. This is where the alleged assault took place. The First Amendment complaint description of the residence in question, however, combined with public records, confirmed that any such residence, to the extent is existed, uh, to the extent it existed at this time, would have been located outside the territorial boundaries of New York City. As such, assuming as well pled factual allegations are true, they are not. They cannot possibly state a claim for relief. Oh man. So I'm assuming that this particular act is for what? New York City? Oh, the New York City admin code. Ooh. So that's another thing. If the act did not happen in New York City jurisdiction, then she cannot bring a claim under that. Ooh, this ain't looking good. Because even when I had I was going down the little rabbit hole. The only residence that I seen at the time was the East Hampton um residence. It was all white and it had a U-shaped driveway. So ooh wee. All right. Third, any viable GMV law claim is time barred under the New York Child Victim Act, which preempts plaintiff's GMV law claim. The First Amendment complaint alleges that conduct occurred 20 plus years ago, well outside the Child Victims Act's statute of limitations. Though the CVA was amended in 2019 to create a 2-year and 6-month revival period, that period expired in August of 2021. Just like the Adult Survivors Act expired, the CVA Act also expired. Plaintiff seeks to plead around the statutes of limitations issues by asserting a claim under the GMV law, which contains a longer revival period. Courts in this district, however, have recognized that the CVA's revival period reempts the GMV law's overlapping and extended one. As such, plaintiff's claims expired no later than August 2021. So overall, what they are saying is that she would not be able to file under any act because the act has expired. She would not be able to recover claims from that GMV law because the act more than likely took place outside the city limits of New York City. We and then she definitely would not be able to uh recover under this claim, the GMV, because it wasn't enacted until December 19th, 2000. And she's claiming that the incident happened in September of 2000. I'm gonna give a shout out to Alex Spiro because he actually sat down and, took a breather, was straight to the point, and called it out. See, the thing is, when you're on the defense side, you have to try to look for little loopholes, right? This is one of them. So they're looking at the act and they're seeing when the act was enacted and they're seeing what the requirements to file under that act. And he made some very good points on this one. Ah, you are so welcome, Pensy. You are very welcome. Yeah, so um I think Alex Spiro is up one. I'm very curious to see what Tony Busby, how he's going to reply to that. They also, and when I say they, let me see who's okay. Yeah, so Busby also had to reply to Jay-Z's or Alex Spiro's motion to preserve evidence, and I don't think I didn't see a response on the docket. So this is their letter addressing that as well. So it says rewrite on behalf of defendant Sean Carter concerning his motion for an order for the preservation of evidence. In an effort to resolve the motion, December 30th, 2024, Mr. Carter served a document preservation notice concerning evidence related to this action and others. Given that Mr. Busby's counsel has indicated that they are permitted to accept service on his behalf, Mr. Carter effectuated service of notice that day. As such, the court need not intervene to issue a preservation order at that time. Accordingly, Mr. Carter respectfully requests to withdraw the motion as mute. Okay, so they don't have to, so he canceled that motion. So he's no longer requesting the preservation of evidence because there's already a document out there that requested them to preserve anything that they had. So that's why they're canceling that. But otherwise, as far as this dismissal, so if the judge looks at this, I'm pretty sure she's going to do her due diligence, and obviously she knows New York rules because does the Southern District of New York. um, I'm just curious as to what she's going to say. I am curious if Busby is going to put out a reply to this. And yeah, that's all I can say. That's all I can say because this is actually a good one. This is a good one. This is really a good one. So y'all let me know what y'all think based off of what Spyro has filed. And kind of me explaining each of those, and you're more than happy to or more than welcome to look these up yourself. So like I said, you had the Adult Survivors Act that actually expired. That's why Cassie was able to file under that act. And then once that expired, people needed something else to, they needed another law or another statute to file under. And so they picked the Victims of Gender Motivated Violence Protection Act. And then you have the Child Victims Act as well, but that also expired. So I don't know how this is gonna play out. Y'all let me know in the comments below. Yes, hot off the press. So hey, they finally Spire was like, hey, judge, this is my argument. This is why I think we should have a motion to dismiss. But let me run this by you to to ask you what your thoughts are. And if you give me the green light, I'm gonna go ahead and file this motion to dismiss, and then, yeah. So I don't know, y'all. Y'all let me know what y'all think, okay? Put it in the comments below. Don't forget to like, share, and subscribe. Until then, you guys be blessed. I'm out. Bye.